Great, we'll go ahead and call tonight's meeting to order. Paul Ennis here, Pinkwitz here. I am here. Greg will be. Is there any public to comment?
Nope.
Great. And just looking for a motion to approve last month's
I'll make
minutes.
a motion to the blessing.
I'll second that. Well, and that'll bring us to our first item of business, the rental registration ordinance kickoff. And Trent, if you want to.
All right, awesome. So Greg, I'm sorry, I introduced myself before you got here. I'm Trent Cunningham from Beatty Schultz Berzik Roads. My firm has been retained to do the rental registration ordinance. So that's why I'm here. Happy to kind of chat about it. As I'm sure you guys are aware, this is a police power ordinance, and so a recommendation from the Planning Commission is not necessarily a requirement, but I do think it's a good process to go through. And when the clerk indicated that she thought that was the kind of process the city was going to follow, I thought that was a really good idea. I think it's better to bring sort of a final product that people with a stake in the city have already considered and tweaked to the council, as opposed to me bringing something fresh off the press to council and having them ask me like, why did you do it this way? So I think the purpose of tonight's meeting is kind of a kickoff, assuming that we're going to have other meetings after this to kind of talk about it, or that it'll forward to council with some revisions from tonight. I think the purpose is kind of just to discuss what's in here, take any questions you may have, and then most importantly, I think, is to get some input from you guys about what you like, don't like, what's appropriate for the city, what's not appropriate for the city, what's overkill, what's not. Those types of things. You are all far more familiar with the city and its needs than I am. And so this draft before you tonight is based on several other drafts that my office has advised on or implemented. So a lot of the provisions in here are not standard, because there's really no standard way to draft a rental registration ordinance, but they're sort of tried and true methods or procedures and sort of structure that we've sort of dealt with before. With that being said, we've incorporated certain pieces of the city's already existing code. Most importantly is the property maintenance code, which sets forth, all the different code compliance that's required, building code, electrical code, plumbing code, zoning ordinance, city code, those types of things. So those are all pulled from the existing regulations and would be sort of implemented into this. And just to back up a step, this came to us with an understanding that there's a lot of rental properties in the city, and oftentimes those rental properties are the ones that are in worse repair or that are in need of some work, but whether it be aesthetically or maybe even code compliance work, compared to maybe single family houses or houses that are owned or other structures. And so the idea was kind of to put in place a structure that would give the city some oversight over its existing rental stock, but not be so overly burdensome that the administrative burden outstripped any benefits that you got from the ordinance. And so just to run through sort of the main structure of this and then get into a little bit more detail, is that the main structure is that it requires an inspection every 3 years, which is kind of what was relayed to us from the clerk as what we thought was a reasonable starting point. Some places do annual inspections. Obviously, that's a much bigger administrative burden. And so every 3 years seemed like sort of a good starting point. The way it works is that they have to register for a rental ordinance, and the registration process entails the inspection. So they come to the city with a rental registration application, and the requirements for that are listed herein. The most important one of those, in a way, is the inspection, which we call a certificate of compliance. So if I own a rental and I want it to be in compliance with this ordinance, I have to get it registered. So I have to submit everything that's required as far as my documentation, site plans, floor plans, owner information, all the sort of typical stuff you would see in an application like that. As well as then I have to approach the city and schedule an inspection, get it inspected, get my certificate of compliance. That then attaches to the rental registration application, which finishes it. And once the city is in possession of a final or finished complete application, it'll issue a written acknowledgement that property is registered, or that those units are registered, and that lasts for 3 years. So then they're all good for 3 years. Other places, other ordinances I've seen have a trigger on change of occupancy. To get that inspection and stuff like that, which again, much bigger administrative burden. As I'm sure you're all aware, rentals change occupancy all the time. And so that's something to consider if we think that that's beneficial, but I stuck with the sort of 3-year revolving cycle here. So once they submit all that stuff to the city, somebody here will be appointed to sort of go through it, make sure it's complete. And that's where it goes. And then we'll maintain a registry of all the rental properties here that are registered. Non-compliance with this, so renting a building without having it registered, renting a building after a failed inspection, those types of things are enforced through the penalty provision, which is towards the end of this, and it's enforced through civil infractions, which I think is a far better way to enforce than misdemeanor prosecutions. It's cheaper. The courts can give you equitable relief so they can compel the person to register their property or to get the necessary inspections. So I think that's a good mechanism. It also tracks with sort of the other enforcement mechanisms in the city. So that's kind of the general overview of how it works. The sort of, as I've mentioned, the property maintenance code is where we impose all of these requirements. If you look on page 1, section 1 there, those are all the codes that would require compliance with this. And so if there's any building code violations, zoning violations, things of that nature, most importantly, the property code itself, property maintenance code itself is in there. It was reported to us that some of the concerns with some of the rentals are that they look really bad. So the aesthetic considerations are bad, or that they're falling into disrepair. And the property maintenance code has certain requirements for maintaining the exterior of buildings that would be imported into this and would be part of the inspection and the compliance. If a property fails an inspection, whether it be the building codes or the zoning ordinance or what have you, the inspector will provide a list of violations to that owner, and then they will have a chance to correct those and re-inspect it. So again, a little bit more burden on the city to kind of identify and provide a list of those violations. But I think it's fair if you're requiring inspections that you would, be fair to tell people exactly what they need to fix about their property. So the inspector right now we've left open. It was reported to me that the city has a building official, but they were unsure at the time that we spoke with them if that person would be the one doing the inspections or what that would look like. So it's currently just drafted in here to have inspections by the city inspector, who's the person who will be appointed to do that by the city council. So now, not to belabor it too much, but I think just kind of a general walkthrough, and I may have to repeat myself a couple times, but page 1, section 1 is the required compliance, lays out exactly what's required there. You'll note the last sentence, I defined rental property. And that term is sort of used interchangeably throughout this ordinance with also the term rental unit. And just to highlight, rental property would be the entire facility, including multiple buildings or the common areas of a multifamily building. Whereas rental unit is the individual units within. That's kind of a nuanced distinction that comes up a lot. Required registration, the main component of this number 2 here is that it's every 3 years, and it imposes the requirement for them to register. The city will also then maintain a rental registry at the top of page 2. And then we're into 3, which is the initial registration requirements. I'm sorry, I left out a piece of my overview. Renewal. So after 3 years, you have to get a renewal. A renewal requires the same stuff as a full application. So everything you see here in section 3 would be required, especially the certificate of compliance, which is your re-inspection every 3 years, with the exception that in a renewal, if nothing has changed, we allow a little bit of leeway for them just to certify that nothing has changed, so that they don't have to resubmit floor plan and get new, drawings and stuff done. I think it's a little bit easier on the applicant and honestly easier on the city, because if nothing has changed, we don't care to have brand new plans submitted every time. So back to 3 on the page 2 here. These are all the requirements. Think of these as the application requirements for the rental registration. Subsection A is the address of the property and all units therein. Moving on to D here, the floor plan, and then the requirements of that floor plan, showing number, size, and location of occupied rooms or habitable rooms, as well as the non-occupied or non-habitable rooms. Site plan, kind of the same concept. Owner's name, driver's license, and state identification number, just to get in contact with them. So we have this part of the registration. Same thing with the registered agent if it's managed by a property manager or a company. Turning to page 3, the top, Subsection H is your certificate of compliance. That's your inspection certificate. Like I said, that's kind of the main component of this, I would say, and sort of the idea is that we included this as part of the registration application, so the burden is on the owner to get the inspection done and then include that as part of their complete application. Other systems that we've seen or ordinances that we've seen put the burden on the municipality to, like, say every 3 years they would contact the person and say, hey, you're up for an inspection soon. You know, here's what dates we have. I think that's more burden on the city. And honestly, like, if you're running a rental business and you're making money off of it, it's sort of your trade, I think, is to make sure that you're up to date on all your approvals. And so it makes more sense for me to have that on the burden be on the owner. But again, all of this is subject to change, whatever you guys think is more appropriate. Just trying to kind of explain the rationale behind the choices that we've made. Subsection I here is an affidavit from the owner agreeing to permit inspections. Sort of a nuanced point here. There's some constitutional issues with just requiring inspections. You have to, and this ordinance requires the city to inform occupants that they have the right to refuse an inspection if the inspector does not have a warrant. It's a Fourth Amendment issue, search and seizure thing. And so this owner's affidavit here that's mentioned in subsection I is just the owner agreeing to permit inspections of the common areas that are not occupied by a lessee. And so you wouldn't have those same constitutional concerns. The owner can consent to those being searched, which is important. And then relatedly, they're also required, I believe it's at the very end of the ordinance here, which not necessarily necessary to flip to. It's on page 5 at the bottom, carrying over onto page 6. They're also required to, I guess, certify that they've tried to gain the consent of the lessees as well, to allow for the inspections, whether it be they just contact them and say, hey, you have an inspection, are you okay with that? And all of that is just to try and get consent from the occupants so that the city doesn't have to go get a warrant every time you want to do an inspection. But constitutionally, if a person rejects entry, then that's the process. You go get a warrant, which is addressed in here as well. So those are kind of the main things of the application itself. Obviously, payment of fees, and then subsection L there is kind of a catch-all for anything else that the city may require to further the purposes of this section. Going into 4 is the renewal registration requirements. I kind of already explained it, but the main thing here is just that first sentence that a renewal of a rental registration must be submitted to the city at least 30 days prior to its expiration. So again, the burden is on the owner to realize my 3-year expiration is coming up. And there's nothing wrong with the city sending like a courtesy email or something to them. I just don't think we need to bind the city to that, right, in our ordinance. So 30 days, they realize it's coming up, they get their inspection taken care of, they submit their complete application within 30 days before it expires. That's sort of how the process is supposed to work. If they lapse into that 30 days or it expires and they are now sort of unregistered for a period of time, this section puts a late fee on them. And the late fee is just equivalent to the inspection fee. So you would just essentially pay 2 inspection fees for that new inspection. The idea there is that we don't necessarily want to have owners not able to operate. And so the city would likely have to sort of operate on a quicker timeline to try and get the inspections done and get them a complete application registered before the expiration of the 30 days. Failure to renew before it expires is a violation of this section, enforced through the penalty provision through civil infractions. 5 is acceptance. Really all that's saying is that once we get a complete application, the city will provide a written acknowledgement that it's complete within a reasonable amount of time. 6 is acceptance of rental registration application and rental registry. Same kind of thing there. It just says that you'll get a written acknowledgement and then it notes what will be in the rental registry, which is each unit that's registered, the maximum number of occupants who can lawfully occupy that unit, the expiration date, and so on. 7 on page 4 here is just changes in registration information, pretty standard, just requires them to notify the city of any changes. Okay, now 8 is the other sort of big section. The 2 main parts of this ordinance are 3, which is the application requirements, and 8. 8 talks about the requirements and procedures for an inspection. Again, they must pass the inspection within a certain amount of time. The certificate of compliance is a component to the registration application. All of that's laid out there. And then inspection timeline, subsection A, it says upon request for an inspection by the owner, the city shall schedule the inspection within a reasonable amount of time. If you notice, I use like reasonable a lot in here whenever it's a city obligation. The idea there is we just don't want to bind ourselves to a specific timeline because things happen. People leave, there's a lot of turnover sometimes. And reasonable amount of time, I think, is a more flexible avenue for the city. Inspection fees going down to B here, pretty straightforward. It'll be set by resolution of the council. Inspection procedures then, the first subsection is just kind of the time, which Monday through Friday, 8 to 6, unless alternative arrangements are made. I think that's reasonable. Nobody wants people in their house inspecting it at 10:30 at night, so I think that's pretty standard. Subsection 2 here, or C2 on the bottom of page 4, the city must notify occupants of the rental unit that occupants have the right to refuse entry. I've kind of already addressed that, but that's just to get around the sort of constitutional concerns. This next subsection that carries over onto page 5 is sort of the same concept. The owner and applicant shall notify the lessee of the scheduled inspection and make a good faith effort to obtain their consent. If an owner, or tenant or other person in charge of the property refuses to permit entry, the city must obtain a court order. And then the court order section is subsection G, there kind of towards the bottom of page 5, which is basically repeats the same thing and just says that if they refuse, the city must obtain a warrant for that. The process for getting an administrative warrant is pretty simple, and in this situation, given the inspections for code compliance, I don't think you'd have any problem with that. There's a SCAO form, or the Supreme Court Administrator's Office publishes a bunch of like commonly used forms all the time. And there's a SCAO form for getting a administrative search warrant. So I don't think that will be too big of a burden, and whoever does the inspections is likely already familiar with that process, but just for your own kind of knowledge on what that looks like. We commonly do that in code enforcement cases where you can't get onto someone's property to see what the violation is. You can get the search warrant that way, administrative search warrant. Page 5, past inspections, just kind of noting that the applicant's responsible for including the certificate as part of its application. This also lays out like 3 copies will be sent to them. One of the copies has to be posted in the rental unit. All that stuff is just sort of standard terms that I've seen in other similar ordinances. Nothing legally saying that we have to keep that in there. So if we think that's overkill, if 3 copies is too burdensome or just kind of meaningless, we can change all this stuff. Failed inspections, I already mentioned, they just have to let them know about the specific violations. Unscheduled inspections, this is the ability for the city to conduct an unscheduled inspection if they believe that there's a violation of the codes or there's some sort of public health and safety risk. Same requirements though for warrants would apply to even an unscheduled inspection. So if they refuse, you have to get court order. I already talked about court orders, so we'll skip over that one. And then owner affidavit and agreement to permit inspections. I sort of touched on this already, but this is basically just saying that the owner will certify that they've made a good faith effort to obtain the lessee's consent to future inspections. Penalties, this one is worthy of some conversation, I think. I sort of just used our standard penalty language in there. Subject to civil infractions, each day it occurs is its own a new violation. So technically every day that they're renting and unregistered, you could issue a civil infraction for that. Exercising our remedies does not foreclose other remedies that are available at law. That's all kind of standard stuff. The one sort of point that I want to bring to your attention is the fines of not more than $500 plus costs and attorney's fees. We see that in a lot of ordinances, and I think that I just included this as sort of our standard language. It's sort of a common misconception in Michigan law that there's a limit on the fine amount you can seek for civil infractions. There's not a limit on the fine amount. There is on costs. So you're capped at $500 in costs for just a typical civil infraction case. And so like attorney's fees, for example, you're not going to necessarily get all of your attorney's fees for prosecuting a civil infraction case. But for fines, you can go a lot higher. I've seen them as high as $1,500. And the way it's done often, and why I think it's a relevant conversation here, is that the fines should be enough to coerce compliance with the law. It's the same sort of concept for criminal laws, right? Like if you do something really bad, you get higher fines. But here, it's sort of a business that's being operated. And so the context where I see really high fines is short-term rentals, which is not applicable here, but you guys have all heard of Airbnbs, I'm sure, and they make a ton of money, especially in tourist towns and that kind of stuff. If someone's like raking in a lot of money off of their business, a $50 fine is like chalk it up to just the cost of doing business. I'll pay the fine as much as I want. I don't really care. It's easier than going through this burdensome process. So the fines should be sort of tailored to where they would be to be able to coerce compliance. So I think $500 in this context might be reasonable. And again, there's no reason that we have to bind ourselves to a number in the ordinance. We can just say fines will be established by a resolution of the city council that can be amended from time to time, and it can be changed whenever city council sees fit. But I included that in here as kind of a placeholder just to bring up this in conversation. It's something that we can definitely change. And if you guys have thoughts on what would be an appropriate fine amount for this, sometimes you'll see tiered amounts. So like your first violation is like $100, second one's $250, third one's $500, that kind of thing. Those are all good processes, and I'll defer to you and city council as to sort of how to structure the fines. And then last thing, 10, that towards the bottom of page 6 or middle of page 6 is exceptions. We were instructed that the city does not necessarily want to inspect or be involved with the state. It's like a pilot program. I've been led to believe it's like a low income housing pilot program, rental apartment that's inspected and managed and regulated by the state here in the city. So the paragraph 10 there is just kind of exempting them from the requirements of this ordinance altogether, as we were kind of directed to do by city council. So this would apply effectively to all rentals within the city, except for that one sort of state controlled and regulated, I guess, low income pilot program housing, from what was reported to us. So that's kind of the basis of it. That's everything I sort of had. I did have a couple, I guess, questions to sort of ask. One of which is that I currently have this structure to amend the city code to put it into chapter 14, article 6, section 14-62, which is a new article and a new section of chapter 14, from what I saw on the codification online. I just kind of wanted to get your thoughts on if we think that's a good spot. It falls into the other chapter 14. I don't have it pulled up in front of me, but it deals with like the building codes and that sort of thing. And so it seemed like an appropriate spot to slot it in. And then also related to that, it looks like the property maintenance code online is not codified in the city's codified city code. And so sort of aside from the ordinance here, I think if the city wanted to codify that, it would make sense, I think, to put that in a similar spot. Maybe just create like an article 7 to put it in there. So I just wanted to flag that for you guys as we were kind of looking into this. I noticed that. And then just questions I wanted to sort of pose to you to maybe get you thinking about the discussion tonight is like thoughts on the registration application. Is it too much? Is there anything else that we think should be included? That's that section 3 that I highlighted. It's a somewhat burdensome application in a way, site plans, floor plans, compliance certificates and all that stuff. So do we think that that's too much? Is there anything else? What about the 30-day timeline for the renewals? Do we think that's too short? Is it too long? Same thing with the late fee. Do we think that that's too aggressive? Do we want to be more aggressive? And then again, like the burden on the owner to get the timely inspection and complete their application. Is that too much to expect from our owners? Are we going to have a compliance nightmare on our hands? Or is that something that we think is reasonable? As for the penalty, do we agree? I already kind of brought up the $500 number. Is that too high? Is it too low? Should we include a max at all? Or should we just allow city council to sort of, I guess, adapt as they move through this with the fee resolution? Any additional comments or concerns? Those are sort of I like to pose questions to give you a chance to kind of have discussion items. And I think that's everything that I had. Yeah, that's everything that I had as sort of an initial tee up for it. So happy to discuss it or take any questions you guys have.
Mr. Chair, may I? Please. Thank you very much. So for section 2, where it states that the rental registration expires, the owner must renew before the relevant rental property can be occupied. What happens in the instance when the property is already occupied?
Good question. I think it would just be enforced as a civil infraction at that point. I don't think we would take any action. Well, let me back up. We would enforce it as a civil infraction. So we would issue a civil infraction to the owner of that property and state that they're in violation of this ordinance. Likely that would, and the way civil infractions work, if you're not familiar, is a lot of times you send a letter and say, hey, you're in violation. If you don't fix this, we're gonna have to charge you or go to court. And then if that doesn't work, you send a ticket to them sometimes, and that ticket might impose a fine. Depending on how the city's civil infraction structure is set up, you can have a violations bureau. I don't know if we have that now, but the point is that it's sort of an escalating process. So it's not like day one, you're occupied, you're unregistered, get your renters out of there. It would be sort of a graduated process. If we got to a point where we sent a letter, sent a ticket, they still aren't in compliance, we file a ticket with the circuit court or with the district court. At that point, the court will set it for a pretrial, and the, I guess, owner would be directed to appear for that pretrial. Courts treat that as sort of a settlement conference, so we would show up and you would just sort of try to settle the case. And the case would be like, hey, get your stuff registered, you know, maybe we'll waive the fines if you get it registered or something like that. If they still don't comply, the court will set it for a formal hearing. There's an informal hearing process too, but for purposes of being simple, we'll just go through formal hearing right now. At the formal hearing, we prove the violation, so you're required to be registered under this ordinance, you're not registered, you know, that kind of thing. The court will then make a finding of responsibility, and the court is authorized in that case to issue injunctive relief. District courts normally can't do that. They can usually only punish through fines and jail, I guess. In a civil infraction context, they can issue injunctive relief. In that injunctive relief, we sort of would have two avenues. I think one's much more likely than the other. The one would be that we would get injunctive relief to require them to get the inspection done and passed and registered. The second one is, I suppose the court could order the renters to vacate because it's an unregistered, unlawful dwelling at the time. And that would be a remedy as well to order them to vacate. I can't really think of a situation where we would seek them to vacate unless there was somebody who was just, we knew was not going to comply with the order and we were going to be back in there on a contempt action later or something like that. So it's probably very unlikely that we would evict anyone. And if we did, it would be through sort of a court ordered process. And even in that situation, the court's likely going to be hesitant to order that. The renters are going to have lease rights over that, which is sort of a contract issue on the side, which could muddy the waters on that too. So it would be a little bit difficult, I think, to actually kick anyone out of their home. Not that the city wants to do that at all, but I think there's a lot of components along the way to get compliance. One of them is financial, like the fines and costs would get pretty high. And back to my fine example, like I think that's why it's important that we set the fines at a level that is enough to coerce compliance. Because if you're renting an unlawful dwelling and you are fined $500 every time you get a ticket, and you're getting a ticket every week or every day, you can see how quickly that's going to be like way more expensive than you're making off of your rental. And so the incentive to continue is gone. So that's kind of how the enforcement process works. But it depends on the situation too. It's very fact intensive.
I think obviously we can't put everything into ordinance. What body is responsible? And this is my second meeting, so forgive me. I don't know what body is responsible for, promulgating the rules or administrative process for that escalation.
Good question. So it would be, I guess, city council could put rules in place for that escalation. Sometimes you'll see policies. Like you said, you don't always put them in an ordinance to bind yourself in an ordinance, but I have worked with communities who have policies in place. Some of them even have committees that they'll assemble, and the committees will decide if something is worthy of taking enforcement action or not. Enforcement is costly. You're usually not going to recoup all your money that you're spending on enforcement. And so the city has to kind of triage what violations are most important in a way. And so a lot of times those policies made by city council or the committee is how that's done. And then in most communities I work with, it's much more decentralized. And so city council would, in a way, sort of deputize like a zoning administrator or a code enforcement officer or some other official at the township to be the person that's sort of in charge of that. They would be the ones that sign the tickets, they would investigate, they would take pictures, they would be the ones that decide if they're going to take enforcement action. In this sort of situation, I would defer to whatever council wants to do, but I think it makes sense for whoever's doing the inspections to be the person authorized to, I guess, or to authorize enforcement actions, because they're going to be like more keyed into this than everybody else. They're going to know what's going on. They're going to know which properties are in violation and which ones aren't. So that's kind of generally how it would go. The planning commission doesn't necessarily direct that stuff, but you could certainly be involved, and definitely be on a committee if that's the way you want to go.
Thank you. Question on the distinction between a lessee and occupant and a tenant.
Good question. So I think constitutionally, the way this would work is that a occupant of a structure can consent to entry. You don't necessarily have to be the legal owner of it, as long as you're like lawfully there, right? And there's a lot of cases, Fourth Amendment cases, where someone's like, partners at the house and they consent to the police, and then the police show up and they don't have a warrant, and then the person who's got drugs in the house shows up and they're like, what's going on? So that's kind of where it comes from. I will say though, in this draft, it's probably could be refined a little bit if we notice places where, like this draft was intended as kind of to initiate discussion. I think we want to refine it a little bit as to who can consent to entry and who can't. I think occupants and lessees probably can. And for purposes of notifying people, from a practical perspective, we can really only notify the lessees because that's whose information we're going to have. That's who we know who lives there. So the distinctions are sort of trying to tie into those sort of things. Like anyone can consent. We don't want to make it harder on the city. So if we get the consent of an occupant and we're comfortable legally with that, like go for it. But for like the notice ones, say lessee, for example, because like we're gonna have to notify a lessee. We don't necessarily know who's occupying the structures. So that's kind of where it comes from. But once we get, farther to where we have a final draft and a recommendation to council, we make sure that those are all buttoned up if we find discrepancies. Hopefully there's not, but.
I guess I was taking it to the extreme of as an occupant, potentially a minor.
Oh, right. So good point. Maybe that's a point that I'll make a note of that to include maybe definitions. Because I don't think a minor can consent to entry, and at least not in all situations. And that's going to test my Fourth Amendment knowledge off the top of my head. So, I think that's a worthy thing to look into for the next draft. And I think, just to back up a step, the constitutional concerns, I mean, obviously they're at play with each individual situation. Like if we have an unauthorized entry and if someone rejects it, and we still enter and inspect it, that's a problem. But the way that the case law in Michigan and other places is applied to these types of ordinances is more of an as applied challenge instead of it's called a facial challenge. So it's like a challenge to the ordinance structure as a whole, not necessarily to as applied to a particular dwelling. And the facial challenges look into just the terms of the ordinance and say that like, okay, does it give an option for them to reject it? Do they have to be notified of their ability to reject? And those courts have held enough to uphold the ordinance from a facial challenge. So the whole thing is not going to be unconstitutional, because we allow for those sort of notice and rejection requirements. But again, an as applied case on a case by case basis, that would be something that we obviously don't want to have Fourth Amendment violations.
Staying in section 8, paragraph F, the unscheduled inspections. I understand the need if there's a possible threat to public health, safety, or welfare, but the end of that sentence, or a violation of any code, seems pretty broad. I mean, if you have a cracked plate on your electrical outlet, theoretically it would fall under that, right? And they can come and inspect.
Right, and that's a good point. I think that's what, and this is drafted to be as broad as possible, because you don't want to bind yourself to things. Like it's better to be broad and then not use it than to not have that option in there, if that makes sense. So that's where it comes from, but there's nothing, honestly, the unscheduled inspections are going to be pretty rare, and they're likely going to be only coming up if there's like some sort of emergent issue. And so the idea there is that if it is a building code issue, for example, and I'm not super versed in those codes, but like just say the structure is like unsafe and we know there's building code violations there. That would just give us the rationale, the justification under the ordinance to do an unscheduled inspection. But if we think that that's too much, I think you could build it out more, and you could say a violation of the electrical code, the building code, or you could say an unsafe, condition, and that's it. So it's just, it's got to be a present threat to the public health, safety, and welfare. And then we just sort of imply the rest of it into that statement. Like if there's something that's dangerous, like a water leak or something, that's gonna be a threat to the health, safety, and welfare. We don't necessarily need to tie it to a code violation.
Mhm.
So, I tend to agree with you. If you think that that's too much, we can strike that and just leave it as.
And I don't want to speak for the whole committee. I just wanted to
Right.
point out from a property owner's rights perspective that a violation of any code is an extremely broad thing that, that city could potentially come in and have a unscheduled inspection of any rental property at any time. And so maybe a reasonableness gauge.
Well, yeah, but at a certain point, the only way the city's ever gonna know about a code violation like that is if someone reports it to the city.
So if I may interrupt for one moment. Speaking right in this line, even for an unscheduled inspection, does the same notice and permissions have to be given by the lessee or the property owner
You,
as would for a scheduled inspection?
you'd have to get either consent or a warrant to enter the property for that. You don't necessarily have to have, so there's other requirements in here about like notifying a lessee ahead of time. You wouldn't have to do that because it'd be unscheduled, but you would, when you showed up, have to say you have the right to refuse entry, or something along those lines. And that's the last sentence there. It says all unscheduled inspections shall be made subject to 8C2 and 8G. And then 8G is just the section right below it there that says court orders, and basically it just says if they refuse, the city may petition for it upon showing obtain a warrant. So that it is sort of the same process, even though it's unscheduled. There's really no mechanism in here for the city to say, we're gonna inspect that property. Aside from the every 3-year cycle that they're gonna be on. And so this is just kind of a way to say, like, we need to inspect that one now, even though it was inspected a year and a half ago. So yeah, it is kind of the same concept.
So, but there's still protections in there where, the code enforcement officer isn't gonna show up at the house at 11 o'clock at night and say, hey, I need to gain entry immediately to inspect this.
Correct, yeah, they would, I mean, actually, now that you mention that, I don't think it expressly incorporates the time revisions, so that, like, and we could add that if we think that's necessary. My personal opinion of that is like, I don't think people are gonna be doing inspections at night anyways, so I don't know that that's like a super material thing, but if we're more comfortable with that, we can definitely include the time requirements and that sort of thing.
I think that fleshing that out a little bit.
Yeah,
In that section would make it feel a bit more comfortable.
sure,
Well, I want to play devil's advocate, if it's a present threat to, public health, safety, or welfare, right? So a circumstance that I can imagine is that there's a giant sewage leak that's happening in the basement, somebody reports it.
Yep.
You want to get in, and it's like that sewage leak is going on, you don't want to say, I guess we have to wait till Monday at 8 o'clock before we're gonna be able to take this action, if there's truly a probable cause to believe that there's a threat to the public health.
yeah, and that's a good point too, yeah, and that didn't think occurred to me, but like weekends are a good example of that, like a Saturday morning thing or something.
Yeah, and right off the top of my head, I wouldn't be able to cite it, but I do think that there's some things outside of this that that exist for, a threat to immediate.
Our maintenance code addresses it.
Got it,
Yeah.
okay.
Yeah, so yeah, that gives them.
The right to do it, plus the health department, if it's something like that, the health department will get involved. They can probably do it.
Yeah, right. But I still think I can propose like a more fleshed out version of the unscheduled inspections that adds a few more parameters. Do we have a consensus on the violation of any code? Like, do we want to strike that and see what a draft looks like without that? I can try to build in more of an explanation of what a health and safety violation would look like without necessarily referencing any code. If we think that would sort of narrow it in, so maybe it would be like threat to the human occupants, or degradation of the structure, things like that. If we're uncomfortable with the code language, I'm happy.
The issue that I could see, tenants are upset with the landlord, so they're gonna call in and say, hey, they got a code violation.
Mhm.
So now they have all these inspections, and the landlord's paying for all these inspections.
Yeah,
And that's where I kind of need to address that a little bit more firmer, so I would take that out because of that action,
sure.
because that never happened.
Yeah.
Okay, Good, so I will strike the violation of any code language. And then I'll just kind of play around with it to make it a little bit more defined. If I thought about it for a while, I can probably even come up with something time-wise that would allow like. Inspections during normal, even an unscheduled inspection during normal circumstances to be. During 8 to 5, Monday through Friday, unless deemed necessary by the city inspector or something like that, to give kind of a caveat. So.
And then just a question on number 9, the last one.
Mhm.
Um. The fine, not more than $500 plus attorney's costs, and then each day violation of this section continues to exist constitutes a separate violation. Could you walk through a circumstance where, let's say that a property owner at February, it's a blizzard, the roof is not. Do the whole, and the roof thing to fix it, they couldn't get somebody to safely fix it, right? Sometimes it's difficult in Michigan to get a contractor.
Sure.
And so would that potentially incur a separate violation on a daily basis, but that would be at the discretion of the city?
Correct.
Okay.
It would potentially incur another violation, like you could write a ticket every single day.
Yep.
Under the plain language of it. It's very common, we include that in our ordinances, and I think the revised Judicial Act even says that too. And really it's just to give the option for that
Mhm.
if it's necessary. I've certainly been in cases where multiple tickets were issued. I've had as much as 9 in one case. And there's reasons for doing that. One of them is that like the fine amounts. So like $500 seems like a pretty reasonable amount, but maybe you'll get someone who's just like, that's the cost of doing business. I'm just gonna pay the fine and move on. Well, like you write them 3, 4, 5, 6 tickets and the fines start to be somewhat expensive. So like, my recommendation would be to leave that language in as just to have it. We never have to use it if you don't want to. 95% of the cases I enforce are 1 ticket or maybe a handful of tickets.
Yeah.
Over a large period of time. I've never seen an officer write a ticket every single day. Usually it's like 3 tickets over a 4-month span, so something like that. So that's where it kind of comes from. And really it is like, to my point earlier about like, it's better to be broad and never use it than to not have the option to use it.
May not shall, like that we may enforce. which-
Oh, I see.
That's
So-
what I'm saying, that we have this.
So saying that it shall be a separate violation is not necessarily saying that we shall issue a ticket
Yeah.
every single day. Shall issue or shall be a violation is sort of just a mandatory way of saying that it will be deemed a violation of this every single time. So I wouldn't necessarily have any concerns about someone arguing that you have to issue that ticket. There's well-defined case law in Michigan about prosecutorial discretion for municipalities. And it goes back to the cost issue, like courts, public policy can't compel a municipality to take enforcement action, but for in very extreme circumstances. Because it's just too costly, you
Yeah.
can't, that's an unfunded mandate, in a way, so. I would recommend that we leave that language in there, like I said, even if we never use it, it's pretty common in your civil infraction ordinance might already say that anyways. Which we can check into, but that's kind of rationale for it.
Perfect, no, and that's great for me, and I'm not suggesting that we're asking that we consider removing it, just noting that could be. Large depending on.
Yeah.
Somebody's preference.
Right, yeah, in my experience, it's only large when it needs to be,
Yeah.
usually, so, yep.
Well, hopefully the spirit of this is like the maintenance code, we're really hoping to form. Healthy partnerships with. Everyone,
Yeah,
the tenants, the landlords.
yep. And in my experience, regulating people who are running a business, even if it is just someone who rents out their other dwelling, like they may not be like an LLC per se, but they are running a business or making money off of it. They are much more receptive to regulations and civil infractions and stuff than say like a blight case. Those are nightmares. If you're just going after someone who likely doesn't have a lot of money, they have a lot of junk on their property, they don't care about the violations. Sometimes there's no way for us to get compliance in those cases, except for the municipality going in and cleaning it up and then charging them for the cleanup costs. So those are a real nightmare. Here, I don't think you're gonna have major compliance issues because your people are making money off of this and they want to be able to run lawfully, you know?
As far as the initial registration requirements,
Mhm.
is there? Is there a requirement for the thoroughness of like the site plan, the floor plan? So we could let people know, as long as it's sketched up and reasonable, accurate.
Yeah, I mean, you definitely could do that. If you're suggesting that we like back off on the detail in these two provisions for the floor plan and the site plan, I think that's okay. I don't think, those come from just similar regulations that we put in place. There's really no rule of thumb, or there's certainly not a lawful reason we have to require all that stuff.
I say require it, just maybe don't require like stamped drawings.
Yeah, right.
Yeah, so if we get something that's representative of what we're permitting, that's acceptable.
Yep, I think, and now that I'm reading these briefly, I don't think there's anything in here that requires them like stamped or engineered drawings or, which you often will see in site plan provisions and stuff. So I think like if someone were to submit a sketch to this that we felt like captured it enough, I think we'd be fine to accept that. So yeah, I think, there's a little more flexibility here than you might think. Because those are a pain when you get.
Oh,
proposals.
yeah, I just wanna make it reasonable for everyone.
Yeah, right, and that's the idea behind the sort of second half of these two paragraphs, like if the owner or registrant previously submitted a floor plan. In the application, it may incorporate by reference the previously filed documents and certify no material change to the rental property has taken place. And so my like thought with this provision, and the same thing with the site plan, is that they probably already would have a floor plan in the site plan. Hopefully, some would, in the context of a rental build, like a multi-family tenant building, I think they would. Houses, maybe not, but I think a sketch plan for a house would be fine. You know, my dad's a carpenter and he's always drawing, you know, his things and, you know, here's the kitchen, here's that, the dimensions. I think that'd be totally fine.
Yeah. So at least our inspector could go and know where the egress is supposed to be,
Mhm.
where the exits are supposed to be, make sure that everything's.
Yeah, and maybe actually now that we're talking, it makes sense to put a sentence in here that's like, you know, as determined by the inspector or completeness determined by the inspector. Or any other information required by the inspector, something along those lines, because I think that would then let them say. Hey, your sketch plan is good, but like I can't read your handwriting, can you give me a better one? Or like you left out this. Shed in the back, what's the shed for? Just to give a little bit more flexibility for them to come back and require more, sort of thing, or in the alternative to say like, this one's good, we have enough information, so. I can, I'll add that in, as well.
Also, I think that codifying our property maintenance code along with this at the same time is a good idea. It's also cheaper to do it when we have more than one to do.
Yeah, I thought that was my thinking too, and I noticed it wasn't codified, and I think it makes sense to put it in a similar spot as well,
Yeah,
so-
I just looked up the spot and I think that's a great place to put it in the ordinance. It goes along with all the other stuff that's in there.
Perfect. I think I don't wanna speak out of like too far ahead of myself here, but I think we could just add a provision to this that adopts that by reference and codifies it into a section. So it could just be added to the kind of end of this, and it would be similar to what you see here in section 1, where it says amendment to chapter 14 of the city code.
Right.
And it would just, instead of saying shall read as follows, it would say like adopts by reference the property maintenance code. This is property maintenance code. I think we can do it that way, but I'll double check into that before we get that far.
you have any experience with communities our size enacting a rental code for the first time?
Good question. I don't have experience with the community of your size doing it. The two communities I pulled from for this that we've worked with in the past are larger. But I did, I guess for lack of a better term, like dull down the provisions. The two I pulled from, well, one was actually pretty bare bones and it was a much larger community, but they have a pretty robust sort of city code that I think deals with a lot of the other stuff, there. And the other communities that I worked with, or that I pulled from for this and that our firm works with is, theirs was much more robust and it required annual inspections and they had to like send a schedule of inspections every year. So I sort of using my judgment thought that that was gonna be way too much and tried to craft one that I think would work for a community, of this size and like this. Once this was up and running, the intent is that it'll just be like a couple of inspections every so often, because once you get them all, the initial lift is gonna be tough. Getting them all inspected and registered. But after that, every 3 years, you're just gonna kind of have a slew of inspections and certifications. The stuff shouldn't change a whole lot. Maybe it's tweaked to a floor plan here and there, but it should be kind of the same information. So, I don't think it will be a major hurdle. And I have worked with communities of similar size that have put in place rental ordinances for short-term rentals, which is a much sort of more hot button topic with a lot more issues, I think. So I think it's like a reasonable thing to do. I don't think there's any reason that it would be inappropriate for your community, and I don't think the burden would be too hard. But if it was, and if we turned out that this was like way too much, it's easily amendable. The city council could amend this in one meeting without public hearings and stuff like that. And so if they determine certain provisions that are causing problems, it's pretty adaptable. So I think we could be pretty easy.
I think it seems very reasonable.
Yeah, yeah.
As far as rolling it out, would there be any issue with us doing even something like quarterly? If you took the number of rentals, let's say it's 100, we said, well, we're gonna try to tackle every quarter 20.
Mhm.
Then the next, that way we can kind of stagger. We never have one big push. And it gives probably the people who are gonna voluntarily come on board, we can get those done. And then give everyone else a little bit of time to get compliant. So even if it takes us 18-24 months
Mhm.
to make one full rotation. I think that's more than a reasonable amount of time for everyone to get compliant.
I think it's a really good idea. And I actually never thought of that until I was talking a moment ago and I was like, oh yeah, every 3 years you have to do all these inspections. And I was like, man, that'll be every 3 years you'll have all the inspections. So staggering it makes a ton of sense. And I wonder if the best way to do that is to build in a grace period for enforcement. So it would leave a lot of discretion to the city as to how you want to roll out the initial registration, but we could add a provision that says like, for the initial 12 months that this ordinance is in effect, or if we think that's long enough, maybe 18 months, I would probably err on the side of going shorter. 12 months that this is in effect, there will be no penalties for violation, or something along, I mean, we could build it out a little more than that, but something like that. But so what that does is that this ordinance legally will not take effect until 30 days after it's published, after council passes it. So you would then have, 11 months after the ordinance is in effect to work on rolling out or phasing in these initial registrations, before anyone would be compelled to comply with it. And I think that does two things that's really helpful. One, it allows phasing of your inspections, and two, it allows a period to like give people more than fair notice that this is going on. And I would even recommend, sending a letter to all known rental units and saying, hey, like, just so you know, this was just passed, it's effective as of whatever date. There's gonna be no penalties for the first 12 months, but we recommend that you contact the city to schedule your inspection, before the effective date of the ordinance goes in place. And that way, after the 12 months is over, if people are not registered by that point, we can either take enforcement action against them, or if we think maybe they just don't know what's going on, we can approach them sort of more gracefully. Like I said, there's nothing that compels you to take enforcement action. But I think building in a grace period like that is potentially a good idea. I don't know that it's strictly necessary, because I think we could let this flow in place and then just do that, like as sort of, without binding ourselves to it, and maybe that's the way to do it. But, so yeah, maybe we wouldn't put it in the ordinance per se, just in case for some reason we wanted to enforce it in that initial 12 months, which could happen. I do think though that we could operate under the understanding that that was the case, and I think that the city could make that known to residents and to rental owners. I think that's a good plan. Yeah. Yeah, because if we can phase the initial inspections, that would be spectacular for the administrative burden. Because it'd be much more of a rolling basis instead of a, oh, like, oh, here comes inspection season again, you know?
Fourth term in election year.
You hit your 12-year mark and it's like, this is the big one, guys, get ready, like. 2036.
Yeah,
Yeah.
plus, obviously, as I'm sure you're aware, like, public transparency and notice to the citizens is super important, and, you're gonna get ahead of a lot of headaches if you can do that, instead of having someone feel blindsided and now they have a ticket in the mail, and they didn't know this was a requirement or something like that. So I think it's a really good suggestion.
Just roll it right down
Yeah,
Main
there you
Street.
go.
I'll try to use it on the floor.
Exactly, yeah, that's right.
Yeah, I think there's, and you know, there's a lot, you can put something on the website that says this is in effect, just so you know, like attention rental owners, something like that. But like, just like anything else in the law, like you're presumed to know the law and to comply with it, so like, it's not an excuse for them to not know. And a lot of people will tell you they didn't know, they did know, so.
Okay, so what are the next couple of steps for this? Are we gonna take another look at a revised draft before we send it to council? Is that?
It's up to you guys completely. My understanding from Kim was that you guys sort of, this was your idea in a way. So I think that if you want another crack at it, I think that's appropriate. Obviously there's the cost component to that, like if I'm attending the meeting and all that stuff like that, but if, as long as the city's okay with that, I'm fine with doing it that way. And the way it would work is I would provide like a red line draft, ahead of the meeting that will be circulated to you guys. That will make the changes we made here tonight. And, it'll be in red, so you'll see easily what was changed. And then we can discuss it, we can decide if there's other tweaks that needs to go in, maybe you don't like what I put in, and we can talk about those provisions. And then whenever we're ready, whether it's next meeting or, you know, 5 meetings from now, whatever the planning commission wants to do. You can make a recommendation to council. Again, it's not a zoning ordinance, so that's not like legally required, but I think given that we're here and that it was your idea and that you guys clearly seem to know what's going on. It makes sense to make a recommendation to council to approve it. And then council will have their one meeting on it and they'll decide what to do, so.
So I guess, I mean, what are your thoughts on this? Do you feel like we need to look at this once again?
Yeah.
Yes.
Yeah, like I said, I'm fine with that, and I can, so because of the Open Meetings Act, we can't deliberate outside of a public meeting, so, I'm fine with the city circulating it to you all ahead of time. And then if you have comments, you can let me know your comments individually, or like I can just show up at the meeting and we can discuss it, but. I'll make sure you do have it ahead of time. It might just be harder to sort of have a discussion about it, because, we can't all talk on the same email chain. That's the process I've used with other communities. I think it works really well. I have a sign ordinance right now in a different city that's going before city council this month, that we've had like 7 planning commission meetings on, so. Sometimes it's more robust than others, but it's a good process, so I'm happy to bring it back to you guys with the changes we discussed. Anything else that we have as far as changes to this draft, or are we sort of good on that? Otherwise, I'll kind of recap what I have and then
I think I feel pretty good about. Yeah, what we discussed tonight. Yeah. Think,
Okay, so what I have then, just so I don't miss anything. Well, one more thing, what are our thoughts on the $500? Do we wanna leave that in there, or do we wanna leave it to council to pass through resolution, so it's
I would
more
leave it in there for now, and
Okay.
then we can revisit it.
next meeting?
Yep.
Perfect, okay, so I have, add property maintenance code to chapter 15 or 14, which I'll look into and make sure that can be added to this draft. If it can't, it's an easy fix, we'll just put it in a different draft. Inspector, is to determine the sufficiency of a site plan / floor plan. That's kind of what we talked about, building some flexibility into that. Reworking the unscheduled inspection provisions to remove, quote, violation of any code, unquote, and to work in provisions about time of inspection unless the city, inspector determines that it's necessary to have, I guess, an expedited inspection or some language along those lines. And then we discussed the 12-month grace period. I don't think I'm gonna build that into the draft, unless you guys think that that's like imperative that it be in the draft. But I think that that's a good sort of understanding to have, and when it goes to council, I think you could make that part of your recommendation that it not be enforced for 12 months. And you can explain why to council, because I think the rationale makes sense. My fear is that we build that in and sort of hamstring yourself to it, and then you get like a super problematic rental that fails an inspection and is like, go pound sand, I'm gonna, rent this for a year, and it's like, man, like that sort of stinks. Now we have a non-compliant renter and we can't do anything about it, or owner. So that's why I don't want to bind ourselves to it, but I think that as a practical matter, it makes total sense. Did I miss anything with those sort of points that we discussed? I was trying to take notes as I went, and I may have other ones in here. Oh, I did miss one. Definitions of occupant and lessee, and is a minor, and who can consent.
Lessee, occupant, and tenant, I feel like. they're all
Yep.
confused.
I think lessee and tenant are probably the same thing. So we can consolidate those, but I think occupant and lessee necessarily have to be different. Because I think that the occupant does have the legal rights to consent to that, so. Okay, so, yep, I got the definitions of those, 12-month grace period, rework, unscheduled inspections. Inspector determines sufficiency of a site plan and floor plan, and add chapter 14, or add the maintenance code to chapter 14. I think that's everything I have, so. Good?
Yeah.
All right, I will get out of your hair then and turn it over to your master planning discussion, and I will, next month is the meeting that you guys are thinking of? To have you back at, or do you meet once a month, or?
We meet once a month.
Okay, yeah, so
As
next
long as
month.
we have enough time to go through it, because we want to come back with more questions.
Okay, yep, I'll try and get it to you. I was told the packet deadline is the Friday before, is that accurate? So I'll make sure you have it certainly by then, but given the sort of minor changes, I think it'll be well before then, I would imagine. So, great, all right, well, nice meeting you all, and I'll see you next month.
awesome.
Thank
Thank
you.
you so much for your
Yep.
time.
Thank you, Trent.
You're welcome. Are you back from Columbia next month?
Yes, I'll be back
Oh,
on.
good. I'll see you then.
Ready?
Ready when you are.
Hey, Trent.
Perfect. Okay, my goal here, I don't think my portion of this meeting tonight is gonna take too long. I think it's just gonna be kind of explaining what I've given you, explaining the next step, and kind of deciding how we want to move forward. So, I'm gonna start by going over that I brought you guys new drafts of the master plan. Walking through this is all of the text of the plan. There are a couple of chapters you guys have not seen yet that you now have. These include the executive summary, the introduction chapter, community profile, where we talk about just the community as a whole, such as location, services, different features of the community. And the other big chapter that we have in here that you have not seen yet is the housing profile. So we provided those to you as well as it has all of the other chapters that we've gone through previously with their edits made in here. A couple items to consider in this is, as you will see, all of our chapter pages and our cover, we need some photos for, right now they're kind of just stab white pages. We have photos of the community, a lot of them we've used, and I really don't want to use photos unless I have to. And you guys live here, you guys are here when fun stuff is going on, so I kind of wanted to open it up to you guys first, to if you have photos, or if you know people in the community who have really good photos, and they want to include them in the master plan, let them send them my way. I think it goes a long way in the look of the master plan. So those are kind of, that's the biggest thing, the biggest component of this master plan that still is not done thus far, is just some of those missing pictures. But all of the content, we have a full draft of them, which is gotta feel really good. It's been a long process to get here. And so with that, I'll leave it up to you guys if you have questions on that. I know it's a lot of information to take in. And I'm gonna give you guys 2 options for the night here in a minute. So you can feel free to do, if you need more, basically what I'm saying, if you need more time to review, you have the time. You don't have to make a decision on what you want to do. I did also provide you guys a little cheat sheet, if you will, that explains all the steps for us to get this master plan adopted. So I'm just gonna quickly outline the steps we have remaining. So when you guys feel comfortable with the draft of the master plan that we have, you are going to have to recommend it to city council for consideration. What city council is gonna do is they have to approve the draft plan for distribution. So what that does is it starts the 63-day review period, which is required by the state law. So we will send out notices to neighboring communities, registered entities, your public utilities, that you guys have drafted a master plan, it's out for review, and asking them to provide comment on it. It's very typical, we don't hear anything back from any of them about the draft, but it is the required step. Once that 63-day review period is over, you guys at the planning commission will hold a public hearing. So this gives all of the residents, everyone a chance to come comment on the master plan if they have opinions on it. From there, it's just up to adoption. So you guys are the approving body for the master plan, unless there is a resolution that has been adopted that makes city council the approving body. When I was reading through the last master plan, it looked like it was adopted by both planning commission and city council. So I think it makes sense to do both of those steps again. So it would start with you guys, you'd have your public hearing, you'd adopt it and recommend it to council, and then council will also adopt it. And then just as a note to you guys, there's a lot of steps we're going through. You guys can make edits or changes to this master plan up through that day of the public hearing. Don't feel like whatever you come up with and we send out for 63-day review, you're stuck with and you can't make changes to. You can make changes all the way up through the day of adoption. So that kind of leads into your 2 options for the master plan tonight. If you feel like you guys really want some more time to review it, flesh out some of those pictures, talk about it a little more, because I mean, it's a lot of content to review in a short period of time. You guys do not have to take any action on it tonight. You can keep it, review it. We can come back at another meeting and go over changes, or you guys can individually email me some changes and we can talk about it, whatever you guys feel comfortable with. Or alternatively, if you're okay with this draft and you're okay that not all the pictures are in it yet, but you like the content, you can recommend it to council to try and kickstart that review process. So I leave it up to you guys. Whichever way you choose is totally okay. It's just kind of how comfortable you feel with where we're at.
I'd kick it up to council. I mean, they still gives us almost, well, at least 2 more meetings to review it, most likely 3. I guess we've been in it every step of the way, so I did, I definitely will go over it all again, but minus the photos, I can't see any major fundamental changes in it.
No, and we can edit anything up till it's done. So I'd be comfortable making a motion to send this draft, of the master plan to
Council.
support. All in favor?
Yep.
Aye.
And then one question for you guys, when is your next, oh, if you have a question, go ahead, you have a
A
question.
quick,
Uh-huh.
note on page 17, it says Prince Road instead of Price Road.
Okay, I will make a note to fix that. Okay, and then a quick question, when is your guys' next city council? That you think this would be on the agenda at?
In 2 weeks,
Planning is March 16th.
we need to put on city council.
City council will be
Next 2 weeks.
Third.
the
Third.
3rd of,
Let's throw that on the agenda so they can approve this.
And so what will happen is, it'll go on the city council agenda, you guys will approve it to go out for review. And then that day after that meeting, either Kim or you or whoever it may be needs to let me know that it got approved, because then what we at Spicer are gonna do is we're going to send out those notices to the registered entities, basically all the people we sent notices to at the beginning of this process saying, hey, we're drafting a new master plan, we're gonna send it to all those people again. So they have to draft a review. And from there, we'll coordinate on picking a day for a public hearing that review's over.
Awesome.
Master plan was pretty simple tonight. There's a couple other things Kim asked me to talk about here and just kind of fill you guys in on that's been happening behind the scenes. Just so you guys are up to speed. The city's been approached by a couple of businesses about change of use requests in the downtown, so one business leaving and a new business coming in. And so kind of how that process works is they fill out an application with the city. From there, we determine if the new use is more intense than the old use. It would go through a site plan review process for review and approval, but that can all be done administratively, so it doesn't ever have to come to you guys as planning commission. It can be done by the zoning administrator. And it really, that process is only required if it's more intense, so the ordinance lists out things like it's gonna require greater parking. There's gonna be more employees, you would expect, more, people visiting that use on a day-to-day basis. So we're working, the city's received 2 applications for change of use that we're working with him on. Just trying to review and make sure everything is good to go there. And then the other request that has come in recently is for the old dollar store. Someone submitted a special use application to turn it into that's why I'm just blanking right now. Mini storage, that's the word I was looking for. Yep, and so with that, currently we're in the process of, we are reviewing it to determine if it's a complete application. And then from there, with a special use, you have to notice it in the newspaper 15 days before the meeting. So you have to have a public hearing on it. And then you also have to send notices to all the property owners within 300 feet. And then it would come to you guys to review the special use and the site plan and kind of, give your final approval on. So those are a couple items that are in the works that we just kind of want to bring you up to speed on. Sounds like you already know a little bit about some of those things that are happening, but so expect that in future meetings.
With the downtown stuff, can we ask to be looped in on that? Seems to me if we're changing use of storefronts in downtown, that the planning commission should at least
Mhm.
be aware of what's happening.
Yeah, I think you guys, it definitely doesn't hurt for you guys to know, just as like, kind of like an update, like, here are the people that are requesting a change in use, they wanna go from this to this, and I think it makes sense for Kim to send you the applications, just so you know what's going on. By your ordinance, there's nothing that you guys can approve, it's administrative, but I agree with you, it makes sense for you guys to be in the know with all the planning stuff that you're doing.
yeah, both of these came in literally last week. Pretty much the same day, so.
Some of them just don't want it, well, yeah,
Mhm.
so it's all proven.
For clarity regarding the storage units, though, we don't have any authority over that. process.
Incorrect. You guys will have authority.
Got it.
Yep, it'll come here, there'll be a public hearing, so public can come speak on it. You guys will review the special use and the site plan and we'll help you guys through that process too, whatever ways you need, whether that be reviewing the site plans, writing a report, committee percent, whatever ask you guys want us. Any other questions?
I like the way why you don't allow something to hold dollars to like the thing that's all town.
No, I've always found the special use requests of site plans very interesting. Anything else?
And that's all I have for tonight. My portion was quick and easy.
Awesome. Anybody else have anything?
Nope, just kind of you.
Great. We'll call this meeting adjourned.
Thank you.
And then assuming you guys got them at the start of the process, you probably did not, because you were new here, but I'm gonna give you guys all my business card too, just so if you like find changes you wanna see or like you wanna talk about something, you have my contact information.
Beat me to it, I was gonna ask you back, if I got it,
I know where I'm gonna put it, though. I know right where I'm gonna put it.
Can someone there end the meeting on the YouTube? I can do it here on Zoom, but the other one needs to be pressed as ending.
I have no idea. They're ahead of us, aren't they? Kim, what time is it there?
Same time as there.
Ah. Just the other hemisphere. Find it there, anything?
I'm fascinated by the mission of the master plan when it talks about the disparity and how different we are from not only Shiawassee, but the state as a whole, because I am both of those categories as far as my wife and I and our children, like we fit into both of the spikes. So it was like, that's us. Like I was looking at it, I told my wife, I was like, this is us. We are part of this bar brand.
Or why?
Yeah.
And I feel like it's odd
Depending
too,
on it.
compared to like, you know, looking at the state as a whole,
Are you on
like I feel
YouTube or
like
you on
you
which one
see
you
like those higher age
In the
ranges or
workplace.
those higher median ages, and you
Zoom
guys
chicken
are
on.
like the complete opposite.
Yeah.
But if you go to, it should have like a thing that says end all or end.
No, I want to spend money, put roofs in, get involved, like
Right.
schools, like.
that's the challenging thing, how do we get the downtown?
Yeah.
And that's really, cause I think about, well, we've talked about over years, me and my wife,
Kenny broken.
like, we want close, and when her sister and brother live in town, like, we try. And look, I think there's a lot of positive energy, and I think there's a lot of, like, the music.
She may have minimized one of the screens.
Oh.
Yeah.
I mean, it takes time and it takes momentum and you guys are moving in the right direction. It's just keeping it going.
I can tell you, just had perspective, though, weather was nice. We rode bikes and quads and everything in the car. Park. Bunch of kids that they go to school with, and we're gonna go a bunch of kids that they don't know, it's like, that's what we do, but I guess nice that we. Down at park and. Moved and everything, and so it's like, we use that aspect, down. Not to mention all the donuts we consume, Tammy's out weekends, but.
Well, and that's been for us too. We did not hold the treasures on it.
Who's it from?
Close out the YouTube brand.
Oh, yeah.
Yeah. My daughter's going to the tree show.
There,
If there's gonna be a day where we're gonna come back.
It'll probably be in Chrome or
Hopefully
Google.
This time.
That's
because
minimized,
Years ago, me and my son.
and that's where you'll end the YouTube.
Sun Explorer.
So we could do have a long.
Well,
conversation about that.
Yes.
Hopefully.
Yeah.
Always on this website, hopefully. I think that's part of the issue too, is being science. Yep. That was.
Yeah.
That was everything.
That forward,
Which forward? The now just finished.
Maybe if you exit out of everything, it'll shut it off.
just you control alt delete. shut the whole thing down.
They're doing.
There you go.
It's really. They're training individuals.
The you
Way
go up
proper
with-
way to use it.
Now, if I close the Zoom meeting, will that close
So
everything?
I'm halfway through her.
Really?
She nominated me.
So you're on.
There should be two screens that are open. One is the YouTube and one is Zoom.
The YouTube is not open.
We can start directing.
It's
that.
probably gonna be under either
Yeah,
the Chrome or Google Chrome.
not either one of them.
See.
Oh, shoot, I hope that was recording.
We can.
Let me double check
watch
YouTube.
Didn't you just go there?
No.
No, still there. Yeah, I'm doing, yeah, like zero.
Says it says it is sending this to YouTube.
Yeah, it's still live.
You look like you're
doing
doing
such a basic ratings
down
down.
What are you doing here yourself?
Killing me.
Oh,
And if they have their business. They never create.
so he's getting out Google.
So. Even.
Well, you guys have a nice-
I would just try and close out either one of those, anything that's open, just close it out.
Okay.
So I'm glad she's doing.
Thank you.
That's you, Kim. Bye bye, Kim.
Bye. There we go. Ah, it's live again. What the fuck?